Everyone, my name is Shazia Khan, and the unit that we'll be doing today is Principles of Contract Law. And we'll be looking at learning outcome 2 today, which is to understand the principal contents of a contract. So before I go into learning outcome 2, I just want to give you a summary of what we did in the last session, which was learning outcome 1. And that was to understand the principal requirements of a binding agreement. In that learning outcome, we looked at what a contract is. We looked at what contract law is in within the UK. We looked at elements of understanding the principles of requirements of a binding contract, and we looked at offer, acceptance. We looked at elements of consideration, intention to create legal relations, capacity, certainty, legality of purpose, and formalities. We also looked at examples of binding agreements and what they curtail, things like commercial agreements, employment agreements, and employment contracts. And we looked at elements of employment contracts and lease agreements as well. We then went on to look at, in learning outcome 1, we went on to look at definition of what a contract is. We looked at key elements again with reference to what each element does. And we looked at explanation of key elements. We looked at examples of contract, and we looked at 1.2, how to make a legally binding offer. And we looked at identifying parties to a contract, so parties involved, the capacity of that party as well. We also looked at the key aspects of a legally binding offer and how an offer can be communicated, so verbally, written, digital, with reference to examples as well. We then went on to look at acceptance of an offer, so it could be unconditional communication, and method of acceptance could be verbally, it could be written, or through any other sort of conduct, digitalization. We then went on to look at how offer and acceptance may be withdrawn with reference to legal authorities and cases. We looked at accepting an offer, and we looked at the most famous case in regards to that is the Carlisle and the Smokeball Company 1893. We looked at invitation to treat and the difference of invitation to treat with an offer. We looked at the postal rule in regards to exceptions to the postal rule, and a really famous case, which was Adams and Linsell, 1818. We then went on to look at electronic acceptance and postal rules and revocation of an offer. We looked at withdrawing acceptance, so what happens before communication and what happens before receipt. We looked at how to enforce a contract. We looked at counteroffer and destroying the original offer, and we looked at the famous case of Hyde and Wrench in 1840 and what the principle was in regards to that of withdrawing an offer. We looked at privity of contract and looked at the case of Dunlop Pneumatic Tyre Limited and Selfridge Company Limited, 1915, and consideration with reference to the Dunlop and Selfridge case, 1915. We looked at promissory estoppel in learning outcome 1 and the elements of promissory estoppel and also the intention to create legal relations. We then went on to look at honor clauses in business relations. And then we looked at the terms invitation to treat and the intention to create legal relations with reference to examples of invitation to treat, and looked at the cases that were mentioned, the case of Partridge and Crickington, 1968, and another case, Pharmaceutical Society of Great Britain and Boots Cash Chemist, 1953. We then went on to look at intention to create legal relations with reference to business or commercial agreements, social or domestic agreements, and looked at cases such as Jones and Padavatten, 1969. And we looked at the element of key principles of intention to create legal relations, and also the purpose and the examples of that. So invitation to treat would be things like advertisements or goods on display, And then the intention to create legal relations could be things like commercial contracts, written financial arrangements between them, and also looked at cases in regards to invitation to treat and the intention to create legal relations. So that was learning outcome 1. Now we're going on to learning outcome 2 in regards to elements of understanding the principal contents of a contract. So the indicative content for learning outcome 2 is to look at representation and what factors court take into consideration in deciding if it would fall as representation or a term. Express terms and methods of incorporation, and the case of Lestrade and Grocop, 1934. Terms implied by custom, trade and usage. Conditions, the case of Poussard and Spears. Warranties and inanimate terms. Exclusion clauses, limitation clauses and operation of these in business, common law incorporation of exclusion clauses, and the Unfair Contract Terms Act and the Consumer Rights Act 2015. So firstly, what are the elements of a contract and what is a contract? So the elements are offer, acceptance, consideration, capacity and intention to create legal relations. So terms of a contract, you have express terms, implied terms, incorporated terms as well, that will be part of a contract. So the next slide is a video that will look at the contractual terms that you can have a look at in your own time. And that video looks at the different types of terms that are based in a contract to get a legally binding contract. So the principle of contents of a contract typically include like things like offer, acceptance, and agreement, legality. So the contract purpose must be lawful, mutual, so both parties agree to it, and the contract is clear proposal of unqualified acceptance and a valid exchange of values between the parties with the legal capacity to agree. So they must have that legal capacity to agree that contract. Key principles of a contract. So there are different key principles of a contract. So terms of a contract, these are specific provisions, including conditions agreed upon by both parties. Express terms clearly stated, either written, that define the parties' rights and responsibilities. Implied terms are not explicitly stated, but incorporated into the contract. Exclusion clauses, which we mentioned in learning outcome 1 as well. Provisions that limit or exclude parties' liabilities. Conditions, fundamental terms of the contract. Warranties, secondary terms that do not go to the root of the contract. Inanimate terms, terms that may be treated as conditions or warranty, depending on the seriousness of the breach. Consideration, as we mentioned in learning outcome 1, the value exchange between the parties. Performance, the actions or obligation parties required to perform. Any sort of termination clauses that will terminate the contract. Dispute resolution, methods for resolving disputes, and governing law, the legal system under which the contract is interpreted or enforced. So these are some of the elements of that. So terms of a contract include elements of that, and it's really important we look at the terms of the contract in regards to that. You've got express terms, implied terms, and exclusion clauses. Let's go back to that. Conditions of so you've got conditions or warranties and inanimate terms. So under English law, the classification of contractual terms is condition, warranties, and inanimate terms, which play a crucial role in determining the rights and remedies available to parties in the event of a default. And as a condition, the first one, a condition is a contractual term that is so essential to the agreement that its breach would fundamentally undermine the contract's purpose. When a condition is breached, the innocent party is entitled to avail itself of the following remedies. The right to terminate it. So the innocent party can immediately terminate the contract. If terminated, the contract can be treated as if it's never existed. Future obligations will be discharged and the parties will be released from the duties to the contract. the right to claim damages or the affirmation. So instead of terminating, the innocent party can choose to continue to perform its contractual obligations concurrent to sue for damages. Next one is warranty. So a warranty is a contractual promise made by one party to another regarding the existence of certain facts or conditions, often relating to the quality or functionality of the subject matter of the contract. Warranties serve as a secondary obligation, offering assurances on specific matters that support the contract's primary objectives. However, unlike a condition, a breach of warranty does not typically undermine the entire contractual relationship. When a warranty is breached, the legal remedies available to the innocent party are more limited than those that are available for breach of a condition. So they have the right to claim for damages, or they have no right to terminate the contract. Inanimate terms, this are contractual terms which do not fit into the categories of conditions or warranties, unlike conditions whose breach allows for the termination of the contract, and warranties whose breach only allows for damages. Inanimate terms require a more nuanced approach. The remedies for breaching an inanimate term depend on the severity of the breach and its impact on the contract. For the breach of a term which deprives the innocent party of substantially the whole benefit of the contract, the breach may be treated as if it were a breach of condition. If a breach is less impactful and does not significantly affect the overall performance of the contract, it will be treated as a breach of warranty. And the cases in regards to that Hong Kong fire shipping case, and another case is Goldrad Limited and BP Oil International in 2021, which highlighted the complexity of issues surrounding the use of inanimate terms. And for consideration, the popular case here is the case of Dunlop and Selfridge, 1915. In this case, Dunlop was a tyre manufacturer who agreed with their dealer to not sell the tyres below a recommended retail price. As part of the agreement, Dunlop also required their dealers to gain the same agreement with their retailers, whose in this instance was Selfridge. The agreement held if the tyres were sold below that retail recommended price, they would be required to pay £5 per tyre in damages to Dunlop. This was agreed between the dealer and Selfridges, which effectively made Dunlop a third party to that agreement. Sometimes after this, Selfridge sold the tyres below the agreed price and Dunlop sued for damages and an injunction to prevent them from continuing this activity. At the initial trial, the decision was given to Dunlop. This was appealed by Selfridge and the decision was reversed. Dunlop appealed. Selfridge argued that Dunlop could not enforce the contract as Dunlop was not part of the agreement between the dealer and Selfridges. On this basis, the question for the court was whether Dunlop had the right to access damages without a contractual relationship. And the court held in a unanimous decision that Dunlop could not claim for damages in these circumstances. The court found that firstly, only a party to the contract can claim upon it. Secondly, Dunlop had not given any consideration to Selfridge and therefore there could be no binding contract between the parties. And lastly, Dunlop was not listed as an agent within the contract and could not therefore be included as a valid third party who had rights to claim on the contract. So performance, it refers to the fulfillment of the contractual obligations, and parties must fulfill all terms. Termination clauses specifies how the contract can be ended, and that's things like breach of a contract, mutual agreement, or frustration of a contract. Dispute resolution, things like ADR, the neutral third party facilitates negotiation, and then arbitration. And the jurisdiction which the contract will be interpreted is an example that it's the UK-based law. This is a table that looks at principal context, so it looks at the description of terms, conditions, warranties, consideration, performance, termination clauses, dispute resolution, and governing law with reference to examples that you can have a look at in your own time. 2.1, outline statutory express terms. So statutory express terms when it comes to contract law is in a contract that come from the employment law. Express terms are those stated explicitly in a contract. And statute terms are based on employment law. and the employer cannot override statutory terms with an express term. For example, employers are entitled to statutory redundancy pay if they meet the criteria. Statutory governance of exclusion clauses. A contractual agreed limit on liability for non-performance of an agreement and a defence to the extent permitted by law. An exclusion clause is a clause that excludes or restricts any sort of liability. And the key features are exclusion clause must be incorporated into the contract at the time of the agreement, and they must be clear, unambiguous, and reasonably under statutory standards. So a business cannot exclude liability for personal injury caused by negligence under statutory provisions. So that's an example of statutory governance of exclusion clauses. So the Unfair Contract Terms Act 1977, it regulates contracts by limiting the extent to which one party can avoid liability through the use of exclusion clauses, such as disclaimers. It applies to exclusion terms within the majority of contracts, including notices that would bring into existence contractual disputes. Despite its name, the Unfair Contract Terms Act does not subject any other types of terms as to test of fairness. The Act itself is rather unclear on the meaning of certain words. What constitutes an exclusion clause is not defined, but the Act implies that is one that attempts to restrict or exclude a liability, make a liability subject to conditions that are restrictive or difficult to carry out, restrict the rights and remedies of an aggrieved party, and restrict rules of evidence or procedure in regards to it. A case in regards to that was the case of Smith and Eric Bush, 1990, where the court ruled that a disclaimer clause in a surveyor's report was unreasonable, therefore enforceable under the Unfair Contract Terms Act 1977. The next act is the Consumer Rights Act 2015. The Consumer Rights Act 2015 came into force 1st of October 2015 and represents the biggest overhaul of consumer law for many decades. And it sets out a simple modern framework for consumer rights. Is designed the Act is actually designed to consolidate in one place key consumer rights covering consumer contracts for goods, digital content and services. It looks at reform and consolidating the law relating to unfair terms in consumer contracts. It looks at consolidating and simplifying enforcers to investigate potential breaches of consumer law and clarify certain enforcers, things like trading standards. It's also given the civil courts and public enforcement bodies greater flexibility to take the most appropriate action for consumers when dealing with breaches or potential breaches of consumer law. And it introduces easy routes for consumers and small business enterprises to challenge any sort of anti-competitive behaviour through the Competition Appeal Tribunal. So the summary table in regards to that, it looks at the exclusion clauses, negligence liability, reasonableness test, fairness requirement, key consumer rights and unfair terms with reference to descriptions, the relevant law that it applies to and which sections of the law, and key examples with key cases as well. So have a look at that in your own time as well, please. So in conclusion, the Unfair Contract Terms Act 1977 and Consumer Rights Act is to ensure any sort of fairness and clarity in contracts and protect any sort of parties in regards to any sort of contracts that are terms and meeting the standards of that contract as well. So how is representation different from a term in contract law? So in contract law, a term is a statement that is intended to be legally binding, while a representation is a statement that is not intended to be binding. For representation, a statement that is not intended to be binding, but instead induces the party to enter into the contract. And a false representation can be the basis for claim for damages under misrepresentation law, but the contract cannot be terminated. And an example here is a statement made by someone who does not have specialized knowledge about the subject matter. In regards to a term, this statement that is a promise or undertaking, and a breach of a term is a breach of contract, and the innocent party can claim damages or terminate the contract. And an example is a statement that is written down, signed, or made by a professional with specialized knowledge. The key difference when we look at representation and a term is a representation is a statement made before a contract is usually formed, usually to induce the other party to enter the contract, while a term is a specific provision within the contract itself, creating a legally binding obligation if breached. Essentially, a representation is a statement that may not be explicitly part of the contract, while a term is part of the contract and is legally enforceable. Looking at factors courts consider in determining representation versus a term. So when deciding whether a statement constitutes a representation or a term in a contract, courts primarily consider factors like the importance of the statement to the contract, whether it's included in writing, whether the relative expertise of the parties involved, the time between the statement and contract formation, and whether reliance was placed on the statement, essentially assessing how crucial the statement was to the party's decision to enter the contract and if it was treated as a key element rather than a mere description. And this looks at importance of the statement and the case of Bannerman and White, timing of the statements, knowledge of the statement, and written contract. So these are elements that the courts will consider when looking at the considering whether it's a term or a representation. Express terms and methods of incorporation. So express terms in a contract are specific conditions explicitly stated and agreed upon by the parties involved, either verbally or in writing, forming the core obligations of the contract, while incorporation refers to the process of integrating these terms, express terms, into the contract, ensuring they are legally binding and considered part of the agreement. This can be done through clear communication, signing a written document, or referencing any other document that contains the terms. Express terms are not open to interpretation as they are explicitly stated and understood by both parties during negotiations. Most commonly, express terms are incorporated into written contract that both parties sign, signifying their agreement. In certain situations, express terms can be agreed upon verbally, though this can be more prone to dispute due to potential misrepresentation. And a contract may incorporate terms from another document like standard terms and conditions by explicitly stating that the reference document is part of the agreement. Properly incorporating express terms is really crucial to avoid any legal disputes, as courts will primarily rely on the explicit words of a contract when interpreting the parties' intentions. And the case is Sperling and Bradshaw 1956, and the case of Parker and Southwestern Railway Company 1877, and the famous case of looking at signed documents is Lestrade and Grogop 1934. Sorry. Terms implied by custom and trade and usage. So terms implied by custom, trade and usage are terms that are inferred from the general practice of a trade or industry. They can be used to supplement the express terms of a contract. So requirements, the custom or usage must be reasonable. It must be widely known and understood in the table. Courts use judicial precedents and statutory interpretation to determine if a term is implied. Understanding implied terms can help legal professionals draft clearer and anticipate potential disputes. And trade by usage, example of that was the case of Hutton and Warren, 1836. Implied usage is elements of a shipping contract may include customary port handling charges and implied term, and by law it's the Consumer Rights Act. So the summary table identifies representation, term, express terms, implied by custom, incorporation by signature, and incorporation by course of dealing with reference to details and case examples to identify these elements. So in conclusion, understanding the distinction between representation and terms, as well as methods of incorporation of express and implied terms, is really important, and courts will take elements or various factors into consideration when determining whether the contractual contract is fair or not. So next one is how may terms be implied in common law? Terms can be implied in a contract in common law in a number of circumstances, including when they are obviously customary or required by statute. An implied term is one that a court has implied in the contract because it has not been expressly included. This may be because the parties did not consider it, did not think that the issue would arise, or simply omitted it to include the term. So implied implied in fact. So terms implied in fact are terms that a court assumes are part of the contract based on the intentions of the parties. They are used when the parties' actions indicate that they agreed to the terms of the contract if they didn't explicitly say so. The term is necessary for the contract to be effective in a business sense. The term is so obvious that if someone suggested it, the parties would agree to it, and the parties' actions after the contract was made sure that the term was intended. So in regards to business efficiency, a term will be implied if necessary to make the contract effective or functional, and that's the Marcotte case, 1889. And then the officious bystander test, and that's the case of Sherlock and Southern Foundries, 1939. There may be situations when the contract between the parties fail to deal with an issue. In such cases, the courts tend to consider if the term is implied, in fact, to reflect the intention of the parties at the time the contract was made. The next is terms implied by law. So implied terms in law are terms that are not explicitly stated in a contract but are legally binding. They can be implied by common law, statute, custom, or the presumed intention of the parties. Key features are they're implied to reflect societal expectations and protect parties in contractual relationships. And examples of terms implied in law, which could be things like health employment contracts, landlord and tenant contract, sale of goods contract. Example of implied terms, health and safety would be one of them, where employees have a duty to provide a safe and secure working environment. Another one could be minimum holidays. Employees are entitled to a number of paid holidays. Another one, valid license. Drivers need to have a valid license to do their jobs. And duty of care, that they have to take a reasonable duty of care. So the distinction between terms in fact and terms in law. In contract law, terms implied in fact are based on the actual intention of the parties, as we mentioned earlier, while terms implied in law are based on the imputed intentions to the parties. So implied in fact is based on the parties' actual intentions, and it's formed when the parties perform duties as if they had a contract. It's assumed that the parties understand the terms of the contract, and it's derived from the presumed intentions of the parties, and it reflects on the principle of the obvious bystander test. Whereas when you look at the element of implied in law, it's based on imputed intentions of the parties, and it's created to prevent one party from being unjustly enriched at the other party's expense. And they arise from statutory obligations or well-established legal principles, and they provide predictable and enforceable standards in contractual relations, and they are confined to particular categories of the contract. particularly employment contracts. So when we look at limitations on implied terms, there are several limitations on implied term. Firstly, the first one is necessity, where the term must be necessary to make the contract work, or it must be so obvious that it's understood without being stated. Secondly, is clarity, so the implied term must be clear and ambiguous. And thirdly, it's express inclusion. If the parties have explicitly excluded a term, it cannot be implied. And the key case for that is AG of Belize and Belize Telecom 2009. Some common law examples of implied terms. So we've got things like employment contracts, so duty, as we mentioned, responsibility to ensure health and safety of the employees, and it's implied by law. The sale of goods acts, goods must be fit for the purpose and satisfactory quality, and that's the Sale of Goods Act 1979. And service contracts, services must be performed with reasonable care, supply of goods and Services Act 1982. Tenancy agreement, landlords must ensure premises are habitable and maintain common areas. And that's the Liverpool City Council and Irwin 1977 case. Commercial agreements terms ensure business efficiency or reflect trade customs, and that's the Marcotte case and Hutton and Warren case in regards to that. Implied terms can be important for maintaining fairness in contracts, even when certain details ain't explicitly stated. They often reflect the intention of the parties at the time of the contract was made, and implied terms can be used in many contracts, as we mentioned, employment contracts, construction, and consumer contracts, tenancy agreements could be used in any of them terms. So terms implied in common law are essential for filling in gaps and ensuring fairness and particular standard relation. And the courts do bear them in mind when they're making decisions on cases and going through each case with its own merits and its own case law. How terms can be incorporated into a contract. So terms can be incorporated into a contract by explicitly stating them within the contract document itself, by referencing another document containing the terms with proper notice given, or through consistent course of dealing between the parties, where certain terms are understood to be part of the agreement, even if not explicitly written down. In all cases, reasonable steps need to be taken to ensure that other parties are aware of the terms involved. So express terms is the first one. Express terms are explicitly stated upon the parties' agreement. They're either written down or oral as well. A case in regards to express terms is Lestrade and Grogan, and the contracts involve both oral and written terms, and courts consider which takes precedent depending on the facts of the case. Terms incorporated by notice. So incorporation by notice is a way to include terms in a contract by giving the other party notice of the terms before or during the contract. The other party must know or be likely to know that the document contains the terms, and the terms must be in a document that is intended to be contractual, and the parties who creates the terms must take responsible steps to bring them to the other party's attention. So, it's really important that the other party knows that the terms are placed in the contract. Key cases are Parker and Southern Eastern Railway Company 1877, where looked at a limitation clause printed on a train ticket was enforceable because reasonable notice was given. And the case of Ollie and Marlborough Court Hotel 1949, where terms displayed in a hotel room were not incorporated because they were provided after the contract was formed. formed or check-in. The next one is terms incorporated by conduct. Terms incorporated by conduct are terms that are agreed upon by the actions of the parties involved rather than by a written contract or verbal agreement. So examples of that conduct could be accepting an offer to buy goods by delivering them, or accepting an offer to sell goods by using them after receiving them, or accepting an offer to provide services by starting to provide them. A party's actions show that they've agreed to the terms, and the party's actions indicate they waived written or other requirements. In a commercial context, conduct will be both positive, such as fulfilling a contract on time to the agreed standard, or negative, like violating the terms of a contract. And the case in regard to terms incorporated by conduct is Sperling and Bradshaw, 1956. Terms implied by law. So terms implied by law are contractual terms that are not explicitly stated in a contract but are necessary for the contract to be valid. And terms can be implied by common law, such as the duty to pay wages. It could be done by statute, which is terms can be implied by statute, so that such as the right of minimum number of paid holidays. Or it could be done by trade custom, which its terms can be implied by trade or industry custom, such as the conduct of the parties. Or terms can be implied based on intentions of the parties at the time the contract was entered into. And the statutory provisions are things like the Consumer Rights Act 2015, Sale of Goods Act 1979, and the case is Liverpool City Council and Irwin 1977. Please look at the cases in your own time. Terms incorporated by reference. Incorporation by reference is a legal technique that allows a contract to include another document by referring to it, rather than including the entire document. This technique is often used in contracts, laws, and regulations. Incorporation by reference is often used in contracts to include policies, schedules, diagrams, or additional terms and conditions. For example, an incorporation by reference to include a supplier, code of conduct, maybe general contract clauses or forced labour covenants. Thornton and Shoe Lane Parking, 1971. That was the case for inclusion and limitation clauses. So we'll go through that now. Exclusion and limitation clauses are contractual terms that aim to restrict a party's liability by either completely excluding certain types of losses or by limiting the maximum amount of damages they can be held responsible for in the case of breach of contract. Essentially, they define what a party will and will not be liable for under an agreement, managing risk by setting boundaries on potential claims against them. While both clauses aim to limit liability, an exclusion clause completely removes liability for specific types of losses, while a limitation clause sets a maximum amount that can be claimed as damages. And as we mentioned, the case earlier, I mentioned Thornton and Shoe Lane Parking, 1971, where a car park ticket containing an exclusion clause was not enforceable because the notice of the clause was given after the contract was formed when the ticket was issued. So here is a summary of table of incorporation methods. So we looked at the method description and the key cases for express terms, notice, conduct, implied by law, reference, and exclusion clauses with reference to the cases. So have a look at that because it identifies what we've done in regards to incorporation methods. Conclusion, terms can be incorporated in contract through explicit agreement, conduct, statutory provisions, or reference. Each method has specific legal requirements to ensure terms are binding and enforceable, and the courts play a vital role in looking at resolving any disputes regarding any sort of incorporation. So 2.5, looking at contract conditions, warranties, and inanimate terms. They are all categories of contractual terms, and the category of term determines the remedies available if the term is breached. So like we mentioned, a condition condition is a vital term of the contract. If breached, the innocent party can terminate the contract and claim damages. And the case we looked at was the Poussard and Spears case in Pond 1876, and the facts and the ruling and the principle are identified on that slide for you to have a look at. Warranty is a less critical term of the contract. If breached, the innocent party can only claim damages. And an example of that is a warranty might involve a car dealer promising to replace a faulty radio in a new car. If breached, the buyer can claim damage for the radio but cannot reject the entire car. Then we've got inanimate terms, which are a term that is neither condition nor a warranty. And if breached, the remedy depends on the severity of the case. And the case in regards to this is the Hong Kong Fair Shipping Company in Kawasaki Kisan Keisha, 1962, famous case in regards to inanimate terms. The classification of terms is important because it affects the rights and obligations of the parties of the contract. It also influences dispute resolution and legal strategy. So each term is important for its own elements and how the courts use that. Discharge of remaining contractual duties. When a condition is breached, the injured party may discharge their remaining obligation and treat the contract as if it was terminated. Breach of warranty does not allow discharge, and the injured party must continue to perform their duties. Breach of inanimate term depends on the severity, as we mentioned, how severe the case is. Here again is a comparison table looking at condition, warranty, and inanimate terms, looking at the definition, the consequences of breach, and the cases, examples that I've gone through that you could look at in your own times on it. Key points: conditions, fundamental terms, breaches leads to termination, warranties, breach allows for damages, inanimate term, evaluated case on the breach of severity of the cases. Understanding these classification terms ensures clarity and contractual obligation, and also identifies remedies that are available. Evaluating the validity of exclusion clauses. So the validity of exclusion clauses is determined by its clarity, reasonableness, and fairness. Courts will interpret ambiguous clause against the party that relies on them. So as we mentioned earlier, an exclusion clause is a contract term that limits or removes a party's liability. They're a vital part of commercial contracts and used to manage risk. Exclusion clauses can limit the amount of liability a party can be held responsible for. For example, they can set a monetary cap on damages. Exclusion clauses can exclude liability for specific types of events, such as maybe defects in goods or loss of data. Exclusion clauses can restrict a party's ability to pursue a claim or claim for compensation. For example, they can limit the time period for filing a claim. And exclusion clauses can restrict the rules of evidence or procedure that apply to a cases. Exclusion clauses can be difficult to enforce in courts if they are unclear or unfair, and the Unfair Contract Terms Act 1977 may be used to consider whether an exclusion clause is reasonable or not, and parties should use clear, ambiguous language when including exclusion clauses when looking at contracts. And the famous case in regards to that is the case of Lestrade and Grogob, 1934. Limitation clauses. So a limitation clause in a contract law limits the amount of damages that one party can claim from another party in the event of any breach. These clauses are also known as caps on liability or financial clauses. Limitation of liability clauses. Business to business contract is a clause that limits the amount of damages a business must pay if a legal claim is brought against them. Depending on the wording of the clause, liability may be excluded only for claims brought during the contract's time frame or to apply to certain types of claims. The limitation of liability is constrained by the statute and common law. Next one is operation of exclusion clauses and limitation clauses in a business. So when we look in business, exclusion and limitation clauses function by allowing a party to contract to either completely exclude specific types of liability or limit the extent of their liability for potential breaches, essentially managing risk by defining what they will and will not be responsible for under the agreement. However, their enforceability can be subject to legal scrutiny, particularly regarding reasonableness under laws like the Unfair Contract Terms Act in the UK. And cases are the Parker and Southern Eastern Railway 1877 and Spurling and Bradshaw 1956. And in regards to elements under common law, is clauses must be clear and unambiguous. Ambiguities are interpreted contract profemtum, meaning against the party seeking to rely on it. The case of Houghton and Trafalgar Insurance 1954, here an ambiguous clause was interpreted against the insurer. Statutory controls on exclusion clauses. And in most jurisdictions, the primary statutory control on exclusion clauses is the Unfair Contracts Act, which essentially means that a clause excluding liability can only be enforced if it passes a reasonable test based on specific circumstances of the contract and the parties involved, particularly any attempt to exclude liability for personal injury or death using void under the Unfair Contracts Act. The core principle of the Unfair Contract Terms Act is that exclusion clauses will be scrutinized by courts to determine if they are reasonable in the context of the contract, considering factors like bargaining power, the nature of the risk, and the parties understanding the clause. The Unfair Contract Terms Act generally prohibits clauses that attempt to exclude liability for death or personal injury, rendering such clauses completely unenforceable. The Unfair Contract Terms Act mainly applies to contracts between businesses, regulating exclusion clauses in commercial transactions. Courts will interpret exclusion clauses strictly applying the contra profentum rule, which I just mentioned, which means any ambiguity in the clauses will be interpreted against the party seeking to rely on it. The next one is the Consumer Rights Act 2015, which applies to business to consumer BTC contracts. Fairness test, which terms must not create a significant imbalance to the consumer's detriment, and unfair terms are unenforceable. The prohibited clauses here are the exclusion of liability for goods not being of satisfactory quality or fit for purpose, and exclusion of liability for personal injury or death. The evaluation of validity. When a party is attempting to exclude or limit liability for loss and damage other than personal injury and death, the exclusion will be valid as long as the term is considered fair. So strengths of inclusion clauses provides clarity by defining the scope of liability. It helps businesses manage risk and reduce any sort of insurance costs if anything does happen. It promotes an efficiency in contractual negotiation. Weaknesses of exclusion clauses is this potential for abuse, especially in contracts involving unequal bargaining power, and the ambiguity may render clauses unenforceable, and statutory controls limit their scope in consumer and certain commercial contracts. The summary table in regards to exclusion clauses, limitations: incorporation by signature, incorporation by notice, incorporation by dealing, the common law control, and the Unfair Consumer Trades Act. and the Consumer Rights Act 2015 looked at the description on the table and also looked at key cases such as Lestrade and Grove, Parker and South West Railway, Sperling and Bradshaw and Houghton and Trafalgar Insurance Company, Smith and Eric Bush, and looked at exclusion of liability for unsatisfactory goods. So have a look at this. Is an outline of what we've done in regards to looking at the different elements of exclusion clauses, limitations. So in conclusion, the validity of exclusion and limitation clauses depends on their incorporation into the contract. Compliance with statutory and common law requirements are fairness. While these clauses provide businesses with risk, the management tools, statutory controls like the Unfair Contract Terms Act 1977 and the Consumer Rights Act 2005 ensure they do not unfairly disadvantage consumers or businesses, and it makes sure that everything is in line with statutory requirements, and also makes sure that the laws are followed, because the laws in regards to unfair contracts and consumer rights need to be followed. So these are some of the references used for today's session. I'm going to just give you a summary of what we've done in today's session. So we've done learning outcome 1 previously. Now we've looked at learning outcome 2 today, which I'll just give you a summary. We looked at understanding the principal contents of a contract. We looked at representation and what factors the courts take into consideration in deciding if it would fall as representation or a term. We looked at express terms and methods of incorporation, and we looked at cases such as Lestrade, Grove, 1934. We looked at terms implied by custom, trade and usage. We looked at conditions and warranties and inanimate terms, and looked at cases such as Poussard and Spears and Pond, 1876, Hong Kong Fair Shipping and qualification, 1962. We looked at exclusion clauses, limitation clauses, and operation of these in business, common law incorporation of exclusion clauses. We also looked at statutory governance of exclusion clauses, Unfair Contract Terms Act 97 and Consumer Rights Act 2015. There was a video available for you at the start to look at the contract terms. And also at the end of each element, we looked at a key table, summary table that you need to look at in regards to what the element is and what the description are. And also we looked at contract in regards to the terms. We looked at different cases that you need to look at and different examples when it comes to doing your assignments. So case law, have a look at in your own time, because there's a lot of case law in regards to that. We also developed a lot on the Consumer Rights Act and looked at key provisions of that act and the key consumer rights and the unfair terms. And we looked at a case of Office of Fair Trading and Abbey National PLC 2009. We also looked, as we mentioned, the key differences between representation and terms, and the elements of how terms can be implied in common law, and gave you examples of implied terms in common law, such as employment contracts, sale of goods contracts, service contracts, tenancy contracts. So use these when it comes to your assignment as examples, okay? So we've now finished the session for Learning Outcome 2, and refer to ebooks. So this session will be recorded and put on Moodle for you to refer to. Refer to any additional reading and any journals or ebooks on Moodle. I've also put a link on there for an article PDF document on terms of a contract, and it's quite detailed, so you can look at that in your own time and have a read around that. Any sort of additional resources are available on Moodle for you, and the module spec as well, an assignment brief. Any questions you've got or any queries or anything, please email learnerwork@ukvarsity.co.uk. And thank you for attending today's session. The next session we'll be doing on this unit, which is Principles of Contract Law, is Learning Outcome 3, which is the next session. So this is all recorded and put on Moodle for you. Thank you for attending today's session.